if this book, before it had become a global sensation, had already helped thousands of women leave situations like Lily was in, I knew that if we could find a way to adapt it, which we knew wasn't going to be easy, then we had the potential to impact millions of lives. And that's why I'm in this business. Nothing against just popcorn movies, but I feel like for me, I want to touch people's souls. And this book and Colleen, it reached in and touched my soul. And I wanted to pay that forward.
Hey friends, it's Katie from Welcome Back to my channel. So, if you were feeling nervous yesterday after Justin Baldoni and Wayfair Studios got hit with a major motion to dismiss filed by Blake Lively, you definitely weren't alone. A lot of you were like, whoa, what does this mean? I was watching Stuart and Keith and they both agreed that this was a really well-crafted motion to dismiss. And yes, it was well written, but that doesn't necessarily mean it's going to be granted. Just because a motion to dismiss is filed at the start of a case doesn't mean it's the end of the road. People often file these when they think there's a possibility of getting out early. But the reality is, motions to dismiss for failure to state a claim are tough to win. These motions are more likely to succeed when there's a jurisdictional issue, a problem with service of process, or some other clear-cut legal technicality. But when it comes to actually stating a claim, that's a much harder hurdle to overcome. So after reading her motion to dismiss, I felt frustrated. I mean, I've dealt with lawsuits before. I've been through several, actually. And so you know, I've never lost a case. I know firsthand what it's like to go through this process. I've even filed motions to dismiss myself, one that I won and another that I lost. The one I lost was a defamation case, and that one is still ongoing. I'm in the final stages and I'm really hoping it gets dismissed soon. We're in the summary judgment phase and I'm optimistic. But here's the thing. Motions to dismiss are notoriously difficult to win when defamation is involved. Judges are often hesitant to dismiss defamation cases outright, especially if the allegedly defamatory statements appear to have merit. In Justin's case, there are some statements that could be considered actionable, meaning they have the potential to hold up in court. So, I get why some of you were nervous. I was feeling it too, but listen, you shouldn't be too worried. In fact, today, I think you should actually feel really hopeful. Here's why. Earlier today, the judge gave a signal that's very telling. He addressed Justin and Wayfair, as well as Blake, Ryan, and Leslie, making it clear that while he's taking the motion to dismiss seriously and will obviously rule on it, he doesn't seem inclined to grant it. That's a big deal. And this all ties back to how he responded to Leslie Sloan's request last week. She wanted discovery to be paused, claiming that it would be too burdensome. She argued that they had been hit with so many requests for production, so much information was being demanded, and she felt overwhelmed by the scope of it all. But here's the twist. Wayfair's team pushed back. They essentially said, look, you just got your AEO last week. If you think this is too much, come to us and let's figure it out together. So, given all of this, I think things are moving in the right direction. The judge's stance suggests that he's not immediately leaning towards dismissal, which means there's still plenty to fight for. So, take a deep breath. This battle isn't over yet, but when it comes to discovery, the judge made it clear that pausing it would be excessive. So today, he officially denied the motion to stay discovery. He referenced the case Robbins versus Candy Digital 2024, and specifically cited the ruling from May 15, 2024, which denied a similar request. Essentially, he's signaling to them, look, I'm making this decision based on precedent, and here's a case that backs it up. He also noted that if any of the discovery requests go beyond what is allowed under Federal Rules of Civil Procedure 26, the defendants could file for a protective order instead. So what I did next was pull up this order, which, by the way, you can find over on cassette. The order states that the defendants had moved for a stay of discovery, while their motions to dismiss were pending. However, the motion to delay discovery was denied. The judge made it clear that just because a motion to dismiss has been filed, it does not automatically mean discovery gets put on hold. There are only a few exceptions to this, like cases involving private securities, But outside of that, discovery shouldn't be paused simply because an early dispositive motion has been filed. Just because these defendants are trying to get the case dismissed early doesn't automatically mean they have a justified reason to halt discovery. And here's something important. The judge also referenced another key ruling stating that, in some circumstances, if there is a valid reason, a court may grant a motion to pause discovery while a motion to dismiss is being considered. But for that to happen, there has to be good cause. The court has to weigh several factors, including the breadth of the discovery request, whether allowing it to continue would cause any unfair prejudice, and, most importantly, the strength of the motion to dismiss itself. This is where things get really interesting. The judge specifically said that the strength of the defendant's motion to dismiss does not justify staying discovery. He referenced another case, Candy Digital, in which the defendants made strong arguments that the plaintiff had failed to properly state a claim for unlawful interference and retaliation under the Family Medical Leave Act. That case was also a discrimination and retaliation case, similar to what's happening here. In that case, the judge pointed out that the plaintiff wasn't even eligible for leave when they requested it, and that's why their employment was terminated. Defendants, including fanatics, tried to argue the strength of their case, but ultimately, the judge ruled that this wasn't enough to justify stopping discovery. The same logic applies here, meaning this case is moving forward, and discovery will continue. That's a major win for the other side, and it means this lawsuit is far from over. The plaintiff had not sufficiently alleged that the defendants were his employer, or that a joint employment relationship existed. However, the plaintiff made a strong argument that the document the Candy Digital defendants relied on should not be considered at this stage. He contended that the court should not convert the motion to dismiss into a motion for summary judgment so early in the case. He also argued that he would have been eligible for FMLA leave when he planned to take it, and that his termination was an act of unlawful retaliation for engaging in protected activity. So essentially, what the judge did was take a step back and look at both sides of the argument. On one hand, the defendants had a solid case, and on the other, the plaintiff had an equally compelling response. The judge then analyzed the arguments put forth by the fanatics' defendants, who argued that the plaintiff had sufficiently alleged an employment relationship, and that any issues in the pleading could be corrected through an amendment. They claimed that even if there were defects in the initial complaint, those could be fixed, rather than dismissed outright. But here's where it gets interesting. The judge made it clear that just because the defendants had a strong argument, that alone wasn't enough for dismissal. He referenced the alternative legal framework outlined by Judge Gorenstein, which essentially states that a party requesting a stay of discovery must make a strong showing that they are likely to succeed on the merits of the case. In other words, they needed to prove that their motion to dismiss had such a high likelihood of success that it justified pausing the entire discovery process. The judge went on to clarify that the defendants had not met that threshold. He explicitly stated that while they made a compelling argument for dismissal, the plaintiff's response was even more persuasive. He emphasized that having a strong argument alone doesn't mean the claim will be dismissed. Additionally, he pointed out that the defendants failed to demonstrate that the breadth of the discovery requests was excessive enough to justify pausing the process. So, to sum it all up, the judge acknowledged that the defense had a good motion to dismiss, but the plaintiff had an even stronger counterargument. Because of this, he ruled against dismissing the claim. He also refused to halt discovery, reinforcing that just because one side presents a solid argument, it doesn't automatically mean the case is over. The ruling signals that the case is moving forward, and discovery will proceed as planned. Just because they've requested discovery doesn't mean the scope is overly broad. In fact, it's actually quite narrow, covering only a limited time frame. In this case, the requested period spans from August 2024 to December 2024, which is when the plaintiff claims the alleged smear campaign began. Ultimately, the judge denied the request to stay discovery, emphasizing that a motion to dismiss does not automatically pause discovery unless it falls under the Private Securities Litigation Reform Act. Since this case doesn't meet that exception, the judge followed standard legal procedure in this district, allowing discovery to continue as planned. Then, in December, the judge ruled on several key motions. One was a motion to dismiss filed by one of the defendants. Another was a motion for summary judgment from a different party, and yet another motion to dismiss from a separate entity. The situation here is a bit complicated. The plaintiff is suing his employer, alleging retaliation for taking FMLA leave. However, there were two different companies involved. One was his direct employer, while the other was a separate entity that worked in collaboration with his employer, but was not directly responsible for his employment. The second company, which did not employ the plaintiff or directly pay him, was only involved in the case because the primary employer had consulted with them regarding the termination decision. Essentially, the plaintiff's actual employer sought advice from this external company before deciding to fire him. The judge reviewed the situation and ruled that the case against the consulting company should be dismissed, as they had no direct role in the employment relationship. However, he denied the motion to dismiss against the primary employer, as well as their motion for summary judgment, allowing the case to move forward. Additionally, the judge gave the plaintiff an opportunity to file an amended complaint to attempt to strengthen his claim and formally establish a connection between his employer and the consulting company. The fact that the judge cited this specific case while also referencing his decision to keep discovery active signals something important. He is taking this case very seriously. Despite the defendant's attempts to get the lawsuit thrown out, early this judge appears unwilling to dismiss cases with substantial claims simply because of procedural technicalities. This pattern has been consistent in many of his rulings. He seems committed to ensuring that legitimate cases are litigated rather than dismissed prematurely. Whether or not you personally believe the claims made by both sides is up to you, but the judge is clearly taking a fair and balanced approach. He recognizes that there are credible arguments on both sides, and he is making sure that cases with significant claims get their day in court rather than being tossed out too soon. This ruling reinforces that perspective, showing that he is not inclined to let strong claims be disregarded without thorough consideration. The judge isn't taking a one-sided stance here. He isn't saying that Blake is the victim and Wayfair is the villain, nor is he suggesting that Wayfair is the victim and Blake is the enemy. Instead, he's making it clear that both sides have brought very serious allegations against each other, which include accusations of theft, sexual harassment, and even extortion. It's evident that he is treating Justin's claim of extortion with a great deal of weight. To me, this signals that the judge is serious about handling this case thoroughly, and it won't be dismissed easily. Even if it does get dismissed, he seems inclined to allow Justin the opportunity to amend his complaint, which is a significant advantage for him moving forward. For Justin and his supporters, this is a positive development because just yesterday, many people were worried that Blake might successfully remove herself from the case. Some speculated that she could leverage the Me Too movement or use a recently introduced California law that limits certain lawsuits. The concern was that this legal provision might work in her favor and provide an easy way out. Then, after she filed her motion to dismiss, Brian Friedman, Justin's attorney, issued a strong statement to TMZ. Here's what he had to say, according to People magazine. Miss Lively's recent motion to dismiss herself from this self-created disaster is one of the most egregious abuses of our legal system. Stringent legal protections exist to safeguard the innocent and provide a fair opportunity for individuals to defend themselves. These laws are not meant to be twisted and manipulated by the privileged elite to serve their own personal agenda. Friedman also addressed Ryan Reynolds' similar legal request. He stated, "As we said yesterday in response to Mr. Reynolds' equally cowardly legal maneuver, we will persist in holding Miss Lively accountable for her malicious actions, which include fabricating false harassment and retaliation claims. Her exaggerated accusations will be swiftly debunked as discovery proceeds, with hard evidence revealing the truth. What we are witnessing here is a major legal battle with two very, distinct narratives. On one hand, Blake is positioning herself as someone who was sexually harassed, arguing that when she raised concerns, her complaints were ignored or led to retaliation. On the other hand, Justin and his legal team are pushing back hard, asserting that Blake is manipulating the legal system to her advantage. As discovery continues, the case will likely reveal more details, and both sides seem determined to fight this battle in the courtroom rather than backing down. She insists that all she did was advocate for more protection for the cast, that she didn't gain anything personally, and that she simply volunteered without expecting anything in return. But that's not entirely true, because she did receive something significant. She got the highly sought-after PGA designation, which is a major achievement in the industry. That alone opened doors for her, making her eligible for prestigious awards through the Producers Guild of America. Now let's break down why this is such a big deal. The PGA designation isn't something just anyone can get. It's a mark of distinction given only to producers who have been officially vetted by the Guild. This designation proves that the person credited as a producer actually performed the full responsibilities of the role, rather than just receiving the credit as a formality. It's a stamp of legitimacy that separates true producers from financiers, executives, or actors, who might negotiate producer credits without actually handling the work. More importantly, it ensures that the right people get recognition, particularly when it comes to eligibility for major awards like the Oscars and Emmys. This kind of industry credibility can significantly boost someone's career, giving them more opportunities for future projects. So what does this mean in the bigger picture? Well, Justin's legal team argues that this was part of an extortion attempt. He claims she didn't just ask for these things, she demanded them, under pressure, knowing that the other party would feel forced to comply. That's why they're leaning into the argument of malice. Justin's team has repeatedly stated that she acted with actual malice, which is a key factor in legal cases involving defamation or extortion. On the other hand, Blake, Ryan, and Leslie argue that Justin hasn't actually met the legal criteria for civil extortion. They keep citing criminal extortion laws, but in California, civil extortion is a separate legal claim with different requirements. According to California law, in order to prove civil extortion, 3 things must be established. The defendant knew their threat was wrongful. The threat included a demand for money, property, or services. The plaintiff complied with the demand due to pressure. And here's where it gets interesting. Property doesn't just mean physical assets or cash. It can include industry recognition, exclusive access, or creative control. For example, if she demanded the PGA credit, the ability to edit the film, or control over the final cut, and threatened not to promote the project unless she got her way, that could legally qualify as extortion. To give an example, civil extortion could be a person threatening to file a lawsuit unless the other party agrees to settle, or an ex-employee of a celebrity threatening to leak private information, unless they're compensated. The pattern here is clear. When someone makes a demand and backs it up with a threat, it crosses into extortion territory. Justin's case hinges on proving that every single one of her demands was met because of these alleged threats. His team is arguing that this wasn't just negotiation, it was coercion. Meanwhile, Blake's side is pushing back, saying that she was simply advocating for fairness and that she didn't act with wrongful intent. They claimed in their motions to dismiss that making a legal threat isn't extortion, but based on this explanation, it actually can be, especially if the threat is used to obtain something the person had no right to in the first place. They also argued that they never physically intimidated or instilled fear, but the law states that extortion doesn't require physical harm. It only requires inducing fear through a specific type of threat. The level of fear necessary to constitute extortion can come from several things. 1. A threat to cause unlawful harm to a person or their property. 2. A threat to accuse them or a family member of a crime. 3. A threat to expose or publicly shame them with disgraceful information. 4. A threat to reveal a damaging secret. And 5. A threat to report their immigration status. In this case, they're arguing that she threatened to accuse them of sexual harassment and assault, and if they didn't comply with her demands, she would make those allegations public. That's the core of their claim, that she leveraged these accusations to gain benefits she wouldn't have otherwise received. Blake's initial accusation and her demand for a 17-point agreement were accompanied by a letter stating that if they didn't sign, she wouldn't return to work and that she reserved the right to sue. That's not the usual way a serious claim of sexual harassment is handled. Typically, such cases go through legal channels, HR investigations, or formal complaints, not direct ultimatums demanding specific benefits in exchange for silence. And this is where the case takes another turn. The article also brings up another key point. What if the defendant had a legal right to take the threatened action? People have the right to report misconduct to authorities, whether it's the police, government agencies, or their company's HR department. However, just because someone has the right to report something doesn't mean they can demand money or benefits in exchange for staying silent. That's where the legal line is drawn. For example, people can legally post negative reviews on Amazon or Yelp, as long as they're truthful and not defamatory. That's protected under the First Amendment. Similarly, anyone can report a suspected crime, an immigration violation, or a workplace harassment issue. But the moment someone says, "I will expose this unless you give me something in return," it moves into extortion territory. In this case, the argument is that Blake wasn't simply reporting misconduct. She was making demands that directly benefited her while threatening to go public if they didn't comply. This is what Justin's legal team is arguing, that every demand she made, from production credits to editing rights, was tied to a threat, and that's why it meets the legal definition of extortion. Meanwhile, Blake's side insists that she was only standing up for herself and the cast, and that her demands were reasonable. Now, whether under the law, this kind of threat is considered unlawful. Essentially, what they're arguing is that Blake repeatedly told Justin and Wayfair, based on the evidence they've provided so far, that if they didn't comply with her demands, if they refused to give her what she wanted, she would expose them. She would go to the New York Times. She would make everything public. She would refuse to promote the film, and she would even withhold communication with Taylor Swift. Now she absolutely has the legal right to report if she was sexually harassed. That is not in question. What she doesn't have the right to do, however, is use that claim as leverage to demand a producer credit, PGA recognition, rights to a film, or even to have a song placed in the movie. That's the point where it crosses into unlawful territory under the statute. Now, in her motion to dismiss, she argues that the extortion claim was only brought against her as retaliation after she sued them. She claims they never had an issue with anything she did before. But there's an email from Jamie Heath, dated June 2024, that contradicts this. In the email, which was sent to Wayfair staff, he wrote about a request from Blake to secure the coveted PGA mark. He stated that they felt this request was unreasonable and, in his words, cold-hearted. He goes on to say that the film was essentially taken away from Justin as the director and removed from Wayfair's control due to what he explicitly refers to as the extortion of Blake. So, this wasn't something they suddenly decided to accuse her of. It was something they were already discussing months before any lawsuit was filed. Without diving into every detail, Jamie Heath made it clear that Justin and his team ultimately agreed to write the letter to the Producers Guild, but not because they truly believed Blake deserved the credit. He admitted they felt pressured, that they had no real choice. Every time they tried to stand firm, she would use her influence and her threats, either directly or indirectly, to make them back down. He even clarified that while they weren't physically forced to comply, the high stakes of the movie, the partnership with Sony, the massive financial investment, and the need to complete the project put them in an incredibly difficult position. So they ended up writing the letter on her behalf, even though it wasn't a true reflection of the situation. He also stated that the letter wasn't about honoring her contributions, but rather a way to document exactly why they wrote it in the first place. Now here's the key takeaway. This proves that the extortion claims weren't some last-minute legal maneuver. They had been thinking about this long before Blake even filed her lawsuit. That's why her argument that they only accused her after she sued doesn't hold up. It's almost like she's trying to rewrite the timeline in the public eye, hoping people will forget this letter exists. Because if people accept this timeline, it directly supports their argument that she used threats to get what she wanted. Under this interpretation, it seems like their case meets the legal standard for civil extortion. If their claims hold up, Blake didn't just make demands, she made them under the threat of serious consequences. And that's where the distinction lies. If you have the right to ask for something, that's negotiation. If you use threats to force someone into giving it to you, that's extortion. So she made it clear what she wanted, and they went along with it. That's the big question here. How does she counter that? She keeps insisting that all she did was offer to help, that she simply volunteered, and that she had no real power in the situation. But based on the evidence they presented, it looks like there's a much stronger case that she actually pressured them into compliance. It'll be really interesting to see how the judge handles this, especially given the legal complexities. On one hand, the New York Times is arguing that they're protected by the New York Shield Law. On the other hand, Black,